Hello, everyone. A very warm welcome to all of you, and thank you for joining us for today's panel discussion on the European Commission's newly proposed Artificial Intelligence Act. My name is Benjamin Muller. I am a senior policy analyst at the Center for Data Innovation, and I'm really excited to welcome you all to my first event for the Center. It promises to be a superb discussion with a really stellar panel on an issue that is at the top of the tech policy agenda in Europe. Certainly, the number of attendees today in the hundreds is testament to the level of interest in this proposal. The Artificial Intelligence Act is the world's first comprehensive binding regulatory framework for this new class of technologies. Supporters and detractors alike recognize the enormity of its impact. This act is not only ambitious in scope, it will be a focal point for the debate worldwide around how to regulate digital technologies in a manner that balances civic rights and public safety against the imperative of innovation and growth. For those of you who want to familiarize yourself with the broad contours of the Act, please visit the Center's website, where we recently published a 3-page explainer of the law. I am very pleased to introduce today's panel. We have Mr. Kilian Groß, head of the AI Policy Development Unit at DG Connect, who was closely involved in drafting the legislation. We have Mr. Axel Voss, a German MEP for the European People's Party and member of the European Parliament's Special Committee on Artificial Intelligence in a Digital Age. We have Mrs. Svenja Hahn, a German MEP for the Renew Europe bloc and also a member of the European Parliament's AIDA Committee. We have Cornelia Kutterer, Senior Director for EU Government Affairs at Microsoft, with a particular focus on AI and privacy. And we have Ms. Annika Link, Senior EU Policy Manager for the European Digital SME Alliance. Thank you all very much for volunteering your time to participate today. We are starting off with a moderated Q&A to be followed by audience questions. Please submit your questions via the Slido panel under the video on the event page, or the Slido link in the YouTube description, and I'm going to try to get to as many of you as possible. And without further ado, let's get started. Mr. Groß, the first question to you. Why do we need an overarching AI law in the European Union? Why not legislate different use cases of AI separately? At the turn of the 19th century, we didn't come up with a single law on cars or law on electricity. Can you explain to us what's different today?
Well, thanks for the question, which is of course very pertinent. Even if I have to admit that we have directives on electricity on the internal market. We had 3 packages. The last one is the 72/2009, and we have as well a number of legislation on cars. And there is one similarity for both, because they are based on the internal market. Because the legislation on electricity is an internal market legislation, because it was an internal market issue to bring electricity to the whole of Europe. And that's the same what we want to do here. That's in the first place, if you look at the legal basis, we want to create a market for artificial intelligence, and we want to avoid fragmentation. We don't want 27 different rules and regulatory systems, but we want to have one where AI can be used in a trustworthy manner and flourish. But of course, you have of course a reason for your question, because you may ask, and other partners in the world do this, why don't we take a more sectorial approach? And that was something we as well discussed in the impact assessment. We see this a bit in the US, where the focus seems more to be, at least for the time being, to look, for instance, at biometric or a public procurement or at certain recruitment tools, and not an overarching horizontal approach at this stage. I think that is a fair point which you can certainly discuss. We thought a lot about it, and our answer to this is, of course, you can do that, But we think that artificial intelligence displays, beside a lot of advantages, which I always like to underline, because we shouldn't look like we're just speaking about risk and dangers, because normally I like to start by saying artificial intelligence has a huge potential and we want to have it, bring it to Europe, but we want to have certain safeguards. And that's, I think, is to put things into balance. But we think that certain features like opacity, the difficulty to predict the outcome, the difficulty to retrace why a decision has been taken, the dependency on data, may lead to certain problems which are inherent in this technology. And they can arise notwithstanding the individual use cases. They can be handled, they can be addressed. They're not there for every AI, because what we said is that we think that nearly 80 to 85% of the AI is probably does not need any regulation or any significant regulation. But there are certain applications in critical functions, like in a car or in a drone, or as well for instance, in recruitment tools or in biometric identification, where we need to make sure that these things are done properly, and where individual remedies need to be safeguarded, so that the individual, if he or she is affected by the AI, has the opportunity to have this checked and controlled in a manner like in the analog world. That's really what we want to ensure, the same level of protection. And we think as these features are always present when an AI is used, it makes sense to address this horizontally and to have one legislation, which of course needs to seemingly be integrated in the different sectorial acts, but which nevertheless has one approach for AI, which has the advantage that we have one standard for AI, one definition, and one way of solving this problem, and not a plethora of different solutions giving the country or given a different application.
Great, thank you for that. I should add, I wasn't clear enough. I meant to say that at the turn of the 19th century, when cars and electricity were just emerging, we didn't preemptively come up with a legislative framework. But your answer makes perfect sense. You want a forward-looking set of rules to enable the uptake and adoption of AI across the single market and avoid fragmentation. The specifics of the law have caused some debate. Mrs. Kutterer, can you comment, speaking from the perspective of industry, what you make on some of the technical requirements for high-risk AI applications? Specifically, I'm thinking of the requirement for high-quality, error-free data sets, and secondly, the requirement for traceable AI decisions, both of which seem to be rather weighty requirements.
Thanks, Benjamin. First of all, thank you for inviting me and Microsoft to this panel. Very pleased to participate in the discussion. And before I go into these technical requirements, again, let me congratulate the Commission for this draft proposal, a very complex issue with a lot of thought going into this. I'd like to say that we're very pleased to see that the Commission has focused on the high-risk scenarios. It is a pledge that we have made, based basically on the experience that we are learning from the use cases that occur in what type of mitigations are required. And this brings me very quickly also to the requirements. We very much like that the Commissioner has made very clear which are the requirements that providers have to fulfill, and those that are for the users or deployers of the AI systems. Whether the right balance is met, we'll have to really think through this. This will take a couple of weeks until we come to conclusion, talking with our engineers, what is feasible, what is possible, what is workable. Where we concur with the Commission is certainly the objectives that those requirements transmit. However, the way the requirements are currently written is very static. And it's eventually not the way the process of a life cycle works. So, and you mentioned, Benjamin, the error-free data sets. So collecting and pulling together data sets in the area of machine learning is done by humans, cleaning up the data sets. this is inherently something which is not error-free. There's humans involved as well. And by the way, not only in that space, but in many of the cycle elements for machine learning. So it requires mitigations at certain points, but these very static holistic views, as the requirements are currently described, will not be workable in practice. So we'll probably need to think a little bit also the relation of the different requirements and how they work together. They might not be as relevant, each of them, for all the AI systems. So and sometimes they might even be trade-offs between those requirements in order to achieve a certain perspective. And you think about some of the tools that are used already to help customers deploy those AI systems in a appropriate way for their purposes. We will always have to make some adjustments. So, for example, you will want to trade accuracy versus fairness to achieve a better outcome for banks providing loans. And these kind of decisions probably need a little bit of work in order to achieve the policy objectives that I think we concur with the Commission we all want to achieve.
Thank you for that. It's nice that we have Mr. Voss here today, who was closely involved in authoring the GDPR legislation a few years ago, and can thus give us a little insight as to how we can expect the path forward to unfold. There's been a number of questions raised as to what next. The Commission's done an excellent job in coming up with the initial proposal, and now it moves out of the hands of Mr. Gross and his colleagues and into Parliament, as well as the Council of Ministers. Mr. Voss, which committee in Parliament can we expect to take the lead going forward? And can you just talk us through the overall sort of marching plan, for the interested observer as to what's going to happen next? And when?
This is a kind of a very tricky question insofar the horizontal approaches of every of these regulations. So if you have Digital Services Act, Digital Market Act, Digital Governance Act, these are, Data Governance Act. So these are all horizontal questions, and there is still ongoing a kind of a fight inside the European Parliament between the committees. And that's why you can't really guarantee that this is going to one committee alone, or or you might have a leading committee or shared competence. So, but I think it's in between of URI, so the Legal Affairs Committee, the Common Market Committee, the Industry Committee, and also the Fundamental Rights Committee. So I guess we will fight for another 2 months, probably just in trying to find out who might be better in the competences than others. Of course, if we are thinking about, and Kilian Gross might be more into the detail, but if we're thinking about this is a kind of a general approach on trustworthy issues, ethical things, in just building a frame and not a specific common market, industry or fundamental rights approach, then of course I would always say this should go to the URI committee. But you never know, you can argue, of course, in all directions. And so now it depends a little bit if we find a kind of a wise approach on all of these and getting a kind of a European Parliament approach. So it's hard to say. I would say because we are already and all the time under time pressure, beside these internal competence fights, then we should speed up with these legislative proposal. I think, or let me hope, if someone is concentrating on these, and also the rapporteur and the shadow rapporteurs, it might or it can be done in half a year or 3/4 of a year. But normally, of course, it takes longer, but we should more concentrate. If someone is the rapporteur, he should speed up, or he or she should speed up in this issue, because we are already facing disadvantages in Europe. Because if you're looking to the competition, the global or worldwide competition, the other big regions like China, like the US, do not have this fragmented starting point what the EU already has. And this is something I would say we have to be concentrated on this and not over-regulating at the end. And so it would be wonderful then if the Council also will be ready to go in, let's say, 3/4 of a year. So then we might come to an end in 1 year or 1.5 or whatever. But this is something, there is more hope than reality, probably expressed by myself, but I hope we can really do a kind of a big step forward here, and having legal security at the end for everyone, and having also definitions in place that the industry at the end can really work with and can come forward, and we will have a kind of a supporting frame for all the AI industry.
Great, thank you for that insight. Relating some of the specific potential amendments or not of the Act, something that comes up repeatedly is that the approach taken is quite heavy-handed when it comes to promoting the uptake of AI technologies by small and medium-sized enterprises, and also ensuring that the European startup ecosystem, when it comes to AI, is vibrant and flourishing. Mrs. Hahn, are you happy with the provisions in the Act for SMEs, such as the sandbox set up? And do you expect some of the requirements or provisions for SMEs to be loosened, or any leeway there for some kind of evolution of the legislation as it currently stands?
That's a very excellent question. I think it's an aspect we follow in all kind of aspects of European policy, because our single market, and especially Germany, where I'm coming from, and I have a feeling a few of the other speakers said, well, small and medium enterprises are the backbone of our economies, and especially when we talk about the digital sphere, European companies are not so much on the forefront, and we have to create an opportunity where those that want to be big one day, that are maybe just an idea today or maybe an idea in the future, can scale up and compete with those that are already big today. So a lot of European policy, and especially in the whole world of digital policy, is centered around how can we create fair opportunities for startups and SMEs. And we're happy to see that the Commission took those aspects into account, looking into how can small and medium enterprises compete with big tech giants, how to reduce bureaucratic burden to extent where possible, while though of course SMEs have to comply with rules as well. So I'm happy to see that the Commission in general is following this principle of proportionality. The bigger you are, the more responsibility you have, and that in combination with the risk-based approach we saw in this proposal, I think this is a really, really good starting point for us to go into the further process. Of course, there is always room for improving the legislative draft coming from the Commission. Otherwise, we wouldn't need the Parliament. So I'm really going to be curious to look more into this. We're just, as Axel said, we're just in the beginning of starting this. We're not even knowing who is going to be main responsible in the Parliament. So we're just about starting this process, getting in touch with SMEs, getting in touch with business association, with all kind of different stakeholders to get their feedback, what they think about this proposal, how this would affect them in their everyday life, and see where we can improve this further and what still needs to be done. So it's going to be really, really interesting part, but keeping SMEs in the core of this, and especially enabling opportunities for those that want to be big in the future. Because this is all about bringing the EU on the forefront of AI and not over-regulating, but enabling through a good legal framework.
Well, thankfully we have Mrs. Link here today, who represents some of Europe's SMEs in the digital sphere. Ms. Link, can you tell us what kind of feedback you've received from members of your organization, and what the general commentary seems to be around the impact of this potential law, and what kind of changes SMEs would like to see going forward?
Thank you very much, Benjamin, and also thank you to the other panelists and also to Ms. Hahn for her focus on SMEs. I'm very happy to hear that, and it's very much also at our concern, of course, to make sure that these requirements are proportionate, because this is one of the things we keep repeating as Digital SME, an alliance of SMEs in the ICT sector, that we really need a level playing field for SMEs in the digital sector. And that's not only about having a competitive market, competitive and open market, or having fair taxation, but it's also about having a level playing field in terms of the administrative burden. So this is also really nicely put in the impact assessment of the Commission in advance of this regulation, that of course SMEs suffer more from administrative burden, that if you have a certain cost, a compliance cost associated with the application of the regulation, this is proportionally, of course, more burdensome on SMEs. So I think the Commission has done a good job here in trying to take these points into account. And the first feedback from our companies is therefore not negative. I think we still have to get our head around all the implications related to the harmonized framework, and what that means in specific areas like medical devices, etc. And I think our SMEs could still hope for is that the Commission and the other co-legislators don't stop short here, but they also think about how can this be implemented in the market? How can SMEs be supported to take up AI and to comply with this piece of legislation? So with the GDPR, I mean, it was mentioned in the GDPR that the data protection authorities should support SMEs and provide guidance to SMEs. But I think we saw with GDPR that SMEs still had a very high, or some SMEs had really a lot of issues making sure they comply with the GDPR and don't spend too much of their resources on that. And perhaps there could be some improvements here, that there could be further support to SMEs who want to develop AI solutions. And yeah, that's maybe one of the things that the co-legislators could look into.
Mr. Gross, are you happy with the sandbox provision as it stands? Do you think that it suspends enough of the rules contained in the Act to make it feasible for businesses to experiment? And what is your comment on some of the things that have been said around proportionality, and also how the Act will actually be applied and impact businesses that are just getting started, either deploying AI or developing it themselves?
Well, I think this is one of the key concerns which we try to address in this regulation to get the balance right between providing safeguards for technology which in certain cases can indeed lead to certain risks, and not to stifle innovation, because this technology brings as well so many benefits and can bring so much added value to our economy and our society. And I'm grateful that you mentioned the impact assessment, because already there we really had a lot of discussion. I think we should always start from the idea, and that's the first thing, that we really want to limit it to high risk. Because I think if you do a high-risk AI application, we should always bear in mind what we speak about. We speak about a car, about a drone, about a medical device, about a recruitment tool, or a tool used to speed up application forms for migration, for instance. In these kind of scenario, every reasonable and responsible entrepreneur and developer would make sure that the quality is sufficient, because it's too risky otherwise. So we think, and that was one of the key ideas in the impact assessment, that in most cases, a developer would do a quality management, because he would need that for his own sake, for his own, because otherwise he might be exposed to liability claims. But as well, a client would never buy such an AI when he or she is not sure that this is safe. There's too much reputational damage, or even too much legal risk. For instance, if the car fails, or if afterwards, maybe you've seen what happened in the Netherlands with the social welfare scheme. When things go wrong, the repercussions at this level can be very serious. So we think, even from that perspective, that we streamline these requirements, which I think most, and that was as well our feeling when we spoke with a lot of companies, what the responsible companies do anyway will even help SMEs, because they will get this label of being trustworthy, so that they can really compete. It will not matter. You don't need to buy it from a big provider, even a sensitive tool, because you can rely on that this tool is good and sound. What we did in addition is, of course, we see for a small and very innovative company, this may be an additional hurdle. That's why we really pushed for these sandboxes, so that they have a safe environment in which they can try and test and prepare themselves for the ex-ante conformity assessment. I think that's very important. That should be seen together with the provision we have for repurposing of data, in order to get access to data which you need to make your system safe and sound. That's another important element. And then we have a provision on support for SMEs, where we say they should get reduced fees for ex-ante conformity assessment. They should get priority access to the sandboxes, and they should get even more access to information. And here we allude a bit to the digital innovation hubs, because you may know that we have the plan to have 200 digital innovation hubs in Europe, and one in each member state should be focused and specialized on AI. That should be the natural contact point for our SMEs, for startups, to help them to get the information and the knowledge, and to build the bridge, for instance, to regulatory sandbox. So I think we thought about a lot of things, so that we can follow them and support them during the chain, in order to make sure that we don't lose the SMEs. And the last message we want to give with this legislation is, for a startup and SME, don't do AI, it's too risky. It should be on the opposite. The message should normally be, in Europe, you can do AI, because it will be trustworthy, and you will be as competitive as a big developer, in the ideal case scenario, if we got it all right, what we wanted. Thanks.
Mr. Voss.
Yes, thank you. I just would like to add something, because as long as I know the European Parliament, I would say we are now coming with a long wish list what algorithms should fulfill. And so this should be, let me say, some of these probably human-centric, human-developed, safe and secure, cyber-secure, transparent, explainable, not misusable, non-discriminatory, sustainable, compliance with GDPR, and so on and so on. And therefore, I think the sandboxes is a kind of a must. So if we are expecting a kind of a result out of AI, so algorithms, then they should try it beforehand. So that's what I would say. It's a very good idea just to have also the possibilities for smaller developers or SMEs to find out if their algorithms are compliant to what we would like to have. And therefore, probably we might come kind to a conflict of interest here. So of course you need quality data at the end to make sure that this is a kind of a gender balanced and environmental friendly and non-discriminatory result. So therefore, of course, you need to have probably also personal data for training your algorithms, and that's might be a kind of a conflict with the GDPR here. And that's why I would say if you can train these, if you can see in these sandboxes how they are functioning, this might really help in not being then not compliant with the result what the legislator would like to have.
Interesting. The Act's definition of AI is quite expansive, obviously deliberately, so as not to create any loopholes. But it also means that software is in the scope of the Artificial Intelligence Act. Mrs. Kutterer, how does Microsoft feel about that as a principle, insofar as software is obviously a very dynamic product? It features patches, updates. With AI, there's a degree of self-learning as well. Do you think that it's realistic to be compliant from a software perspective with an act that requires ongoing monitoring and conformity assessments? Any comments on that?
Not a conclusive one at this stage, at least, because we're really looking into the way the Commission has described the definition and scope. Of course, is always a critical element of the discussions. I think there is two ways to think about this. In a way, as the Commission has focused on high-risk scenarios, it doesn't matter as much. Now, from a compliance perspective, the definition is critical in order for compliance teams later on to exactly know against what areas are covered by the required by the requirements per se. So it becomes very critical. It's also interesting, though, that that there is no specific distinction made in the text between software and products. So there's sort of a streamlined horizontal approach towards the high risk in relation to the requirements, and it's noted. But I also confess that we haven't really entirely thought through what type of implications that actually means down the road. I would think that this could be a critical aspect for liability discussions as well, but we are not that far yet in the analysis on the topic. Now, just to repeat, where it becomes really important is so that our compliance officers at the end of the day will know which areas will be covered by that regulation. For that, the scope is absolutely critical.
I'm going to move to a question from the audience that I think Ms. Hahn might be well placed to address. The question is, do we expect a lengthy discussion process between Parliament, Member States and the Commission? This is something Mr. Voss has already touched upon, but then the key of the question is, how fast can industry expect final clarity?
Well, I would say we have three very sexy acts of legislation, if you might say so, about politics. And these are clearly the Digital Market Act, and the Digital Service Act, and the Horizontal AI Regulation. This is certainly going to be those files that will have the biggest impact on how to prepare the future economy of the EU. Because this is really about, are we managing to create a digital single market, and are we making the EU fit for a digital age to be actually competing in that and keeping on the forefront. So those will be very high-ranking topics. It's unclear where in the parliament it will be. And then it kind of depends on how many Easter eggs the parliament tends to find in the proposal from the commission. Axel already said there is going to be a lot of demands from all sides of the houses, what all should be fixed and addressed in this legislation. So it's that combining that, bringing that, shattering some dreams, maybe what cannot be fixed in this regulation, will be intense debates. And then, of course, we have the main focus, but we also have some more intense sidelines, as I'm a bit worried about the aspects on biometric surveillance, for example, that the Commission says in general it's forbidden, but the exceptions are so broad that I'm not really seeing an actual ban there. So we're going to have broader discussions. We're going to have some side battles as well coming up from different aspects. So I'm fairly certain that this is going to keep us busy for a bit of a longer time, and that this is not a thing that will be dealt with in a year.
Well, Mr. Gross, the stated aim of the Act is also to provide a degree of legal certainty and a sort of forward-looking dimension so that businesses have some clarity and consistency going forward. I wanted to ask you specifically around the issue of amending some of the provisions of the Act through delegated acts. For instance, expanding the list of high-risk applications or turning voluntary labeling into compulsory labeling. Could you talk a little bit about how you foresee these delegated acts to work in practice? And then maybe we can get a comment later from one of the MEPs around whether they think the balance of power here is fair, that this is basically in the hands of the Commission alone.
Well, thanks a lot for the question, but of course the Commission is aware that the real legislators are Parliament and Council. So as Axel has put it very rightly at the beginning, we make a proposal and then the co-legislators decide, and they give us a mandate to amend certain things via delegated acts. And even then, of course, there's a scrutiny by the co-legislators. So that's just to put things into order. Why did we, perhaps I can rephrase the question a bit, why did we put in at a number of places delegations for acts? This was a deliberate choice, because we had a bit to square the circle, because we wanted to have on the one hand side a future-proof legislation, which is open, because the AI is very fast moving and nobody really in this knows which applications will really be out there in 3, 4, 5 years, and which will really cause problems and perhaps to a lesser extent be problematic than we may imagine that today. So we need an element in ability, because we did not want to have a very open legislation where then the economic operators have to make complex assessments by themselves, basically to understand, could what I do be presumed by others or judged by others at a later stage to be risky, and therefore I should now undergo an ex-ante conformity assessment. I think that we really wanted to avoid this unclarity. And we tried to balance these two needs by, on the one hand side, being very precise, very concrete. So that's why we have the annexes, Annex 1 with the techniques we use for AI. So that should be for a developer very clear, the technique I use is considered to fall under the scope of this regulation, or by the products which we cover, or by the use cases. So that should be, no law is perfect. I'm aware of this as a lawyer, but we try to be as practical and pragmatic as possible, so that it should not require sophisticated legal advice for a developer to find out whether what he or she is planning to do would fall under the regulation and in which kind of risk category he or she would find himself or herself with a certain given application. But being as precise and trying to be as well concrete, so not to speculate what could be a risk in the future, but really to look on the facts, what is a risk now and what do we need to do now, of course requires a concrete list. and we cannot cover all the things which may come up in the future. And therefore, we need these delegations to have this flexibility to adapt smoothly the act for the future. But of course, in a democratic society and in our democratic system, this has limits, and this is clearly as well in the regulation. That's why we have a definition of AI. We cannot go beyond that in Annex 1. We have to respect this framework. We cannot go beyond the categories in Annex 3, which we have identified for high-risk use cases. So that is the boundary which the legislator, the parliament, and the council will fix. But within that boundary, we will have a bit of marginal maneuver to propose if facts show or evidence comes up that there is need for amendment under the scrutiny of Parliament and Council, of course, because they can always stop delegated acts if they wish. But within there, we would foresee or would plead for a certain marginal maneuver, so that we do not always need to wait 5 years until we have the next legal revision in order to update the act, but that we allow smooth updates to keep it, that it can still grow and go with time in the lifetime of this act. I think that is very important. And for just to avoid confusion, for the developers, we foresee that only those applications which come on the market or in use after our regulation, the transitional period is over, or after a delegated act has been adopted and is in force, it will be covered by this regulation. There will never be a retroactive application. So if you put something on the market now, you will not have to redo this test. Only if you substantially modify it or renew it, then of course the picture will be different. Thanks.
Mr. Voss, a comment, and then I have a question for Miss Link.
Sorry, so I can't resist because Kilian is totally right. The development of AI and technologies are faster than our ponderous proceedings as a legislator. And so this is why we should catch up with the rapid changing world, and this might be a way forward with these delegated acts. So we have had in the parliament already also this idea when it comes to this civil liability question on AI. Then we also thought, so if we are fixing all these ones, but then we have to steadily look into the market, what might be a next high-risk AI system, and then it should be legally clear that this is somewhere listed. So I do not know if we as a parliament will have totally different ideas on approaching these, but we need to be quick and for having this legal certainty at the end in place. So we need to step up also as a legislator, and this might be a very good approach so far.
Interesting. Ms. Link, we're spending a lot of time here talking about some of the finer details and nuances and technical complexities of the law, which is really reflective of just how vast it is and in how granular detail it impacts the deployment of AI. Could you offer a perspective from the point of view of SMEs, how they deal with a law such as this? Just to help us understand what's the reality of how this gets absorbed and implemented. Presumably they don't have large in-house compliance departments. What, in your experience, can we expect them to do going forward to ensure that they are in compliance with the law?
Yeah, thank you, Benjamin. I think it's a really good question, because a lot of times, especially the small companies, the micro ones or the small ones, they have, well, the CEO is actually dealing with a lot of these questions. So it's not necessarily, they don't necessarily have a department that can actually look into this. So this is also what we mean by making sure that the administrative burden is not too high, because of course, if you have yet another type of legislation that comes on top of the already existing requirements that a company has to fulfill in terms of taxation or like HR or any type of legislation that they need to deal with at the management level, it's usually down to the CEO, who of course has other more important things to do actually, because he has to think about how to make money and how to make sure that the business actually moves forward, develop the ideas, etc. So this is really why it's so important to think from that small perspective of a small company, because I mean, we all know that from our daily experience. We can't divide ourselves. You have to focus on one thing and then do the next. And if there's a lot of requirements coming on your table, you have to deal with that and try to understand it. But what I also wanted to mention, actually, in relation to that, we have this focus group on AI. So a group of 150 SMEs in the that develop AI solutions. And we actually asked them also what they think are the main hurdles to AI adoption in Europe. And here, one of the hurdles they mentioned were access to data, lack of financing or capital for them to scale, and a lack of talent and skills. So they didn't say that there's a lack of regulation. So, but of course, I think from the conversation, we did understand that they do see a point that it's important to regulate AI, because they also see the risks associated with AI in certain areas. But I think in order to make sure that we in Europe or European businesses can actually succeed in AI, we also need to really think about these other aspects too.
Thank you for that. One question that comes from the audience and is proving very popular, and I want to invite anyone to contribute to answering it, but in the first instance, we'll go to Mr. Gross, since he's actively been involved in writing the legislation. How should we interpret the prohibition on AI systems regarding the use of subliminal techniques that cause harm? What kind of definition do you have in mind of what counts as subliminal, and what kind of examples exist?
Well, thanks for that question. We were very, we used to refer to a pyramid when we speak about our risk scheme. And the top of the pyramid is by nature small and should be very focused, because these are things we want to prohibit outrightly, because we think there can never be a case where we want to see this, or there can never be a justification for this kind of things. So we want to be very clear that certain uses we just don't want to see. That's why we have been very focused in this, because in other cases, because we had a lot of discussion, should we not target, for instance, put in all kind of basically unfair commercial practices or excessively targeted advertising or something which you may not dislike or find excessive. But we think first we should as well see the other legal acts which we have, because we have a DSA, it was already mentioned, and we have an unfair commercial practices directive, where I think will provide very good tools in order to address the key items in this respect. And we want it to be complementary to this. And we think, therefore, what we have prohibited here are things, what we call here subliminal techniques, which could do harm, physical or psychological harm to people. And with subliminal, we don't use a new word, because this is something which is as well known by the AVMSD. You can find that there. That's not a completely new concept. This means it's not really in your consciousness. So you use an AI to influence a person's behavior in a way to which this person cannot really react, because it's addressing its subconsciousness. Be it, for instance, with tones which you can't really hear or distinguish, or be it with quick pictures which appear on your screen just at the verge of a half of a second, so you don't really realize them, but they nevertheless have an influence on you, and that can cause you certain harm in a physical or psychological way, and that we don't want to allow. For instance, you could imagine that you want to push a driver to drive longer than he should drive, because you have a commercial interest in that you can keep him or her driving or awake with sounds which you cannot really realize. So this is really something where where the key is manipulation. You manipulate the human brain in a way, and that's why we want to prohibit it, where the human is not really addressed as a human who can take a free decision, but it's addressing with intention the subconsciousness. And that we find is something which is so clearly out of any normal social context that we should simply prohibit it.
Do you think, Mrs. Kutcher, that is an example of something that might be difficult from an industry perspective to plan around, given that the finer details of what counts subliminal, for instance, micro-targeting, social media involves techniques that might come to the edge of what Mr. Gross just outlined? Or do you think that there is sufficient clarity here, what is meant, to avoid any kind of confusion?
No, I think it would be quite helpful to provide more examples in this context. We haven't heard that many yet. It seems that the use is specific here. So again, that is why examples in this space are probably needed. And I can only report back from discussions with industry where there has been a lot of question marks and what specifically the Commission had in mind when they described this one. If I have the mic, so to say, if I may allow very quickly just to go back to Annika's points. In the context of, as you may know, Microsoft has been very actively advocating for regulation around facial recognition technologies. It was one of the first use cases where we felt there is a high risk. In our own experience with our standard that we have started to implement, that was a use scenario where we clearly felt there is a need for regulatory guardrails around the use beyond GDPR. And at the very beginning of those conversations in Europe, there was not so much enthusiasm for that. And so at one point, it was a really interesting experience because we were sort of like a little bit frustrated with the lack of feedback we got. And so we started to think about whether we should bring providers from Europe on facial recognition technologies together. And actually we did so. And we reached out to smaller companies that provide facial recognition technologies for security purposes in for example, conferences and different use scenarios, also for law enforcement in cases. And all were interested in a code of conduct, and all were basically, I mean, we don't need that anymore because now we sort of have the regulatory proposal. But what was interesting was that their core concern was fragmentation, because what they experienced is that then whatever the in particular public sector use cases, they come up with public procurement requirements and they differ from one country to another. So for them to be able to actually market their products, they wanted a regulation, they wanted guardrails, and they wanted in particular a uniform single market. That was sort of the core issue for them. So it's just interesting. It was not, the regulatory burden that they were concerned about. It was really the fragmentation across Europe that they were most, and I hope I don't misrepresent what they were saying. This was sort of conversations in moving forward with the regulatory scheme as the process was very slow in convincing legislators that this is actually needed. So this is an interesting thing. I want to, if I may, also just two things that I think are really important to mention. Those, my starting point was the requirements certainly need clarity. They need to they need also a little bit of reflection that we are dealing with socio-technical issues. They're not only technical, they're not only social. It's a combination that really requires engineering groups to have a culture shift in how they think about developing those tools. It's a complicated process to put these governance procedures in place. And that is, I think, I really hope that in the legislative process, we will find the time. Axel was talking about we need to do this fast, but we also need to find the time to really understand the difference in what that means, so that the objectives that we are all trying to achieve can be achieved with the tools. And also recognizing that even within the requirements, too statical requirements will not allow us to innovate in the tools and the practices. So currently, and this is the good thing on the other hand, what we think is very important, as there are no standards yet, and I hope the standards will be more on the procedures and not on the specifics, determined requirements. What is really, I think, forward-leaning from the Commission is that they accept that the research state of the art will serve in the self-assessments to fulfill the requirements. Because what we learn is that there's a very active research community currently that is constantly improving the ways in how to be more transparent, how to be more fair, how to be more accurate. And these are both with tools, with technology, but also with practices. And we need to allow this space to actually achieve the goals that we all want to achieve. And I think that is also very important.
Thank you. We are getting towards the end of the event, but I want to make sure that all of our speakers have a chance for a quick lightning round final comment on what they want to leave the audience with. I'm going to go clockwise from Ms. Kutra, moving to Mrs. Hahn. Final comment, please.
Well, I since I just had my word, I just want to reiterate, it's really the experience that the industry has in trying to already operationalize responsible AI should serve and hopefully is welcome in order to get the clarity that we need into the obligations for the industry to achieve the objectives.
Ms. Hahn.
Well, this is just a starting point. So I think this is one of the very first early discussions that we're going to have quite a bit of in the next years to come. I think we should always keep in mind that after all, the goal should be that we have an innovation-friendly, technology-open, and proportionate set of rules that limit risks, but should mainly aim at increasing opportunities for the EU to be one of the leading drivers of innovation in AI and other emerging technologies. So this is going to be the challenge that we see in front of us, and at least this is what I'll be working for in the Parliament.
Mr. Voss.
Thank you. So for me, of course, it might be important that we have this risk-based approach, focusing on high-risk systems, excluding harmful technologies, but also that we have a kind of a good control in place. The definitions has to be very precise for avoiding legal uncertainty, and so that I'm looking forward to work on this proposal. And if we are doing or not overburdening these, then we might really come a very good step forward.
Ms. Lick.
Yes, thank you. So I think the Commission has done a good job to propose something.
Even though it says you are unmuted, we can't hear you.
Okay, can you hear me now?
Yes.
Okay, yay, great. Thank you. So yeah, I think the Commission has done a good job in kind of going to the regulatory part of the coin, but I think the innovation part is also really important. And I know there are a lot of efforts here, but I think we really still need to work on these aspects, such as access or data, and making sure that money is available for these companies to scale, because I don't think we are lacking the ideas in Europe. We're really lacking the supporting framework. And what Ms. Kutter said as well about the digital single market, this is super important as well for the companies to have a harmonized single market. So, yeah.
And Mr. Gross, you have the final word. Could Mr. Gross hear me? Or have we lost Mr. Gross? Well, we seem to have lost Mr. Gross, but at this point in time, I just wish to thank you all for participating. This was a really engaging, stimulating discussion and a nice preview of what awaits going forward. Thank you for joining us today. And the recording of this conversation will be made available on YouTube and our website. And now I just wish you all a wonderful evening. And thanks again for joining us today.
Thank you. Bye.
Bye.